The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court. And we have our...
Now, do I call the case, Madam Clerk, or do you call it?
I'm happy to, sir.
Go right ahead.
All right, first case number 19-1954, Sonia Perez Vasquez versus Merrick Garland.
Good afternoon, Your Honor. Jonathan Westreich on behalf of the appellants.
Yeah, Mr. Westreich, it's good to have you with us, and Ms. Carter, it's good to have you with us. I'm sorry that we're not in Richmond, but it's the best we can do. And I'm glad to hear that the clerk has already put the new Attorney General into the case. Mr. Westreich, you may proceed.
Thank you, Your Honor. For one housekeeping matter, in preparing for today, I noticed a couple of typographical errors in my brief, including a case citation that was incorrect in the table of authorities. I'm always embarrassed to find such things, and I do apologize for any inconvenience caused by those such errors. I'll get right to the meat of the matter. The standard of review, of course, to overturn a denial of asylum if it's manifestly contrary to law. Factual findings are reviewed under a reasonable adjudicator standard, whereas legal conclusions are reviewed de novo. For the Convention Against Torture, the standard of review for the finding of facts and substantial evidence to be overturned when a reasonable adjudicator would be compelled to a contrary conclusion. The appellant in this matter and her daughter fled Honduras, the United States in November of 2016, applied for political asylum and withholding of removal under the Convention Against Torture on July 26, 2017. In February 2018, the Immigration Court denied relief and ordered removal, was timely appealed to the BIA, and then in August of 2019, the BIA dismissed the matter. A timely appeal was noted to this court. The appellants seek asylum and withholding of removal under Sections 208 and 241b(3) of the Immigration and Nationalization Act, and protection under Article 3 of the Convention Against Torture. They seek to terminate removal because of defective notice under the Piera recession standard, although I will acknowledge that is the weaker of my arguments today. I'm not abandoning that argument, of course, but it is the weakest of the three. For asylum to qualify, the appellants have to demonstrate that she is unable or unwilling to return to her native country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, or membership in a particular social group or political opinion, and show a nexus between the protected status and the persecution. This court in Lagos v. Barr, which as of the writing of my brief was not formally reported, it is now reported at 927 F3rd 236, addressed this matter with some detail, and Judge Harris, who I believe is on the panel or was scheduled to be on the panel, was on the panel for the Lagos matter. Regarding unable or unwilling to return to her native country because of a well-founded fear, threats of death have long been held on this circuit to qualify for persecution. The Zavaleta Palisana matter, as well as Hernandez Avalos. And extortion can be sufficient even if you're only harmed if you don't pay. Again, the Zavaleta Palisana matter. And past persecution is sufficient to establish a well-founded fear of future persecution. In the matter before the court, the appellant and her daughter were threatened with death if they don't pay. In addition, further threats were directed to the minor daughter of the appellant. After the matter was reported to the police, further threats...
How old is the daughter?
I apologize, Your Honor. I don't know that off the top of my head. I know she was a minor at the time. I apologize. I don't have that date in front of me.
That's fine. Were these unconditional threats of death? What were the
threats were, if you don't pay us, we will kill your daughter and kill you. So
how many times?
There were multiple occasions of this. So she paid several times, and then stopped paying. So just like in the Lagos matter, there were a pattern of threats. If you don't pay, we will kill you, followed by her fleeing the country. And the Lagos matter involved Honduras, just as the matter before the court. The appellant also testified that there was nowhere she felt safe in Honduras.
Counsel, this is Judge Harris. I wonder if I could take you to sort of where the agency disagreed with you, because the agency didn't say, at least, that they didn't think this threat counted as persecution. They said there's no nexus between the claimed particular social group of the nuclear family and the threats here. So do you want to address that?
So the nexus, you're right, that is the focus of the disagreement. And but there's also the political element of it. So in Lagos, the decision, the failure to pay is a political act, not simply a refusal to pay a debt. So the nexus is the political act of, I'm not going to pay the debt. If you don't pay us, we're going to kill you. That's the nexus.
So let me ask you, counsel, you bring up the Lagos case. Is that the case that is most applicable here from the Fourth Circuit?
It certainly is
addressing the nexus between a membership in a nuclear family and the persecution she supposedly suffered?
It may not be the most current one, but I believe is the most on point with the facts here. So just as in Lagos,
I guess I'm thinking of the Hernandez Cartagena case.
I apologize, Your Honor, that case is not coming to memory. But I focused on Lagos. I'm sorry?
Go ahead, continue.
I focused on Lagos because the similarities in the facts were so very much, were so close. Now, there is one difference in Lagos, of course, is that she had the additional element of being a single parent, which is not present in the matter here. But the facts in Lagos, the failure to pay, followed by additional threats, I think was very important. In addition, in this case, the appellant contacted the police, followed by further threats from the extortionists. So I think that is the nexus. Threats to kidnap and kill the daughter, just as was in Lagos.
But I'm sorry, the nexus to what, right? You have to show that the threats were connected to her relationship with her husband who's sending the money, right?
Yes.
And so, okay, so let me just ask you, I understood the agency to be suggesting that maybe there was no evidence of any causal link there because, you know, he'd been doing it for 11 years before they first threatened her and things like that. So maybe it was just a coincidence. What's your response to that? What's the best record evidence that there's a causal link here?
The evidence is that the threats escalated. I think what may well have happened, I think the record would support this, is the extortion increased when they realized they could get their claws into the appellant through her daughter because of her connection to the husband who was here in the States. So it was targeted to her based on the husband being here. You have
and what do we do? Did your client say at the hearing, this is something the agency talked about a lot, did your client say at the hearing that she didn't know why she was being targeted? And if so, how would you handle that?
She did say she did not know. And the answer is she doesn't. How could you possibly know the intent of another unless, of course, they you know, if they had come and said, we are targeting you because, you know, we don't like people of your ethnicity, that would be direct. But where do we ever have that? You can base.
Well, I thought they kind of did come to her and say, we're targeting you because we know you get money from your husband in America.
Yes, they did.
Okay.
But in addition, she has the refusal to pay, which is the political act. And after asserting that political opinion, I'm not going to pay you, further threats. And so the nexus there between the threats and her political opinion is there. Did I answer your question, Your Honor?
It did. Did you raise this political opinion issue before the agency? Because it didn't seem like you did. But if you can show me where you raised it.
Trial counsel asserted the Convention Against Torture and asserted the argument that she was the facts. So the facts of the threats, the reports to the police, and the subsequent threats, those are the facts that underline the political act of that I'm talking about here. I do not believe that it was expressly asserted as a political act in the lower court, but the facts that underline the assertion were presented. I think that's sufficient to give this court jurisdiction. I believe my distinguished counsel for the government may disagree with me on that point, but that is certainly my position. And also,
you normally have to give them a fair shot at it to preserve it, right?
Yes, Your Honor.
And you didn't give them a shot at it here. Did you know that had you heard that the Fourth Circuit's jurisprudence on these death threats in immigration cases is, according to the government, all messed up?
Your Honor, the clerk asked me to point out my 15 minutes has expired, and I was directed to advise you when I noticed that. Okay,
well, I want to see if you can answer that question first. I won't charge you to.
I apologize, Your Honor. The question was, am I aware that the government doesn't like your rulings on threats?
Death threats. They say it's all messed up. We ought to get it straightened out.
I was not aware of that.
We revised that in an in-bank case a few days ago. You wouldn't, unless you listened to that, you might not know about it.
I did not listen to that. I'm not aware of it, and it's I'm not sure how the government's argument would be that I would never say to the Court of Appeals, or frankly any court, that they were messed up on anything, Your Honor.
Well, I think that's the messed up part is my language. I'm not going to trip it.
Yes, Your Honor.
I'm not going to trip it to the government lawyer, but that's the gist of it. But you don't know about it. That's fine. This is, I'm sort of setting up, I guess, the government lawyer to ask her about it.
Yeah, but as I look at the government's arguments for a moment or two on that issue, on it seems a thread going through some of the arguments of if you let this satisfy the requirements, then they'll open up the floodgates. And I don't think that's an appropriate basis to make a ruling. I think that we need to look at and I think the case, the law in this circuit is we have to look at each one individually. And I think that particularly with the framework from Lagos, I think we satisfy the requirement. My time has expired, and I will stop talking now. Thank you, Your Honor.
Well, before you leave, when you go back to your seat, I don't know what kind of technology you have.
Your Honor?
You're relying on this Lagos case, and you do have a serious waiver problem, I think, on the political opinion aspect of it. But the nexus issue that's in this case is squarely addressed in the Hernandez-Cartagena case, which was last year. Lagos was the year before. And I'm sort of miffed that you don't know about that case.
I apologize.
I think it's more, my perspective, it seems to be more to what we are dealing with here in trying to determine if there's a nexus, and it dealt with the economic incentive in that case too. So I implore you might want to take a quick look at that.
I'm not sure I'll be able to find it in time to address it this morning, Your Honor.
Argument went on something that looks like to me it's waived on the political opinion.
Yes, Your Honor.
All right, take it.
Ms. Carter?
Yes, Your Honor.
You there?
Yes, I'm here. Can you hear me?
Yes, and I can now. Good to have you with us.
Thank you. Thank you. Good afternoon, and may it please the court. Margot Carter for the United States Attorney General Merrick Garland. I hope you're all staying.
You may be the first lawyer in the country to represent Attorney General Garland. You know that?
Oh wow, that's exciting.
Well, he just got sworn in a couple hours ago, didn't he?
Yeah. Yes, absolutely.
Go right ahead.
Sure thing. The court should deny the petition for review. In this particular case, there is nothing particular about the petitioner's family here that led the gang members to target the petitioner. The petitioner's husband did give her money, and the gang members knew about it, and the gang members wanted that money. But at the end of the day, this comes down to the substantial evidence standard, and the record doesn't compel the conclusion that the reason why the gang members targeted the petitioner in this case was on account of her marital relationship.
So I will ask you, are you familiar with the Hernandez-Cartagena case from this circuit?
Yes, Your Honor, I am. I think
I'm happy to hear that. And so why is that case not similar to what we are dealing with here? In that case, it was an issue in which the immigration judge had focused, the court found, narrowly just on the gang's reasoning for targeting the family, rather than on his reasons for targeting the petitioner herself and not some other person. And there seems to be a lot of connectivity between that case and this case. How do you view that case in terms of its influence on this one?
Well, thank you, Your Honor. I think that Your Honor is right to observe that there is some overlap between the two cases. On the other hand, this case is distinguishable because in Hernandez-Cartagena, the immigration judge had failed to address unrebutted evidence that compelled the conclusion that family was at least a central reason why the petitioner was targeted in that case. And in the present case, the evidence simply doesn't compel that conclusion.
Well, let's go straight to where this Hernandez case is going. The court there dealt with an issue in which the gang, it has been saying, the IJL said the gang was motivated by monetary gain, and therefore her ability to pay her, so to speak. But the court went on to say it is enough that the protected ground be at least one of the central reasons for the persecution. And here she's alleged this nuclear family and this money that she's receiving from her husband and is because she's part of this family is the reason, the connection between the persecution and the gang that's going on here.
I think that in the current case that we're looking at right now, our case can be distinguished here because in the Perez-Vazquez case, the petitioner testified that the targeting by gang members of people was widespread, that there was not something about her family in particular that led the gang members to single her out. And moreover, that conclusion that was reached by the agency.
She was receiving money every month from her husband, and they knew she was going to that bank and getting the money and coming back with it. And the standard here is a substantial evidence standard. So there's a legal error by the immigration judge if he applies the one central reason standard incorrectly.
That is correct. If the immigration judge had applied that standard incorrectly, that would be a legal error. On the other hand, in this case, the immigration judge considered the evidence, and at the end,
and he found that but for petitioner's husband being in the U.S. and sending money back, she would not likely have been targeted or threatened. He found that. So if that was a but for reason for her persecution, doesn't that by definition satisfy the one central reason standard?
Well, I think at bottom, the court needs to examine the motive of the persecutors under Elias Zacharias, and where the motive of the persecutors is grounded in their desire to enrich themselves and not grounded in any particular animus toward her family. I mean, I think the fact that
Counsel, this is Judge Harris. I feel like we have rejected that particular proposition just over and over again, that there doesn't need to be animus against the family as a family. It's just the family relationship has to explain why, of all the people they could have targeted out of greed and in order to enrich themselves, they picked this person. And I guess I have basically the same question as Judge Nguyen, so maybe it's not helpful just to ask it again, but under the, the standard as we have laid it out so many times now, once the IJ says, yeah, like, but for the relationship with her husband, this would not have happened, I am sort of struggling with how that doesn't dispose of the case on nexus grounds. I mean, there's lots of other stuff going on.
Right. And we can move to the unexhausted Convention Against Torture claim and the Cortez challenge if the court is interested in those two issues, but we can focus on this nexus issue. I think that, again, it comes down to the fact that the petitioner was chosen because she has money doesn't necessarily mean she was chosen because of her marital relationship. That money could have come.
But it doesn't have to be because the agent, we've told the agency time and time again that there can be multiple intertwined motives.
That is definitely possible that there can be more than one motive, but at bottom, when the petitioner herself has said that she was unsure why her family was chosen, and when other people who were not her family were also targeted, and in addition, there's evidence that members of her family besides her were not targeted, it was a reasonable conclusion for the immigration judge and the board to look at that evidence and conclude that there wasn't a motive on the part of the gang members to target her on the basis of her family membership.
Would it make a difference, counsel? I mean, one thing that we talked about in Hernandez Cartagena and some other cases is that, the fact that the money is coming from a relative allows the gang to sort of leverage that relationship. It's a sure stream of income if it's coming from someone who will be very sad if the gang kills this woman and his and her daughter. So there's a reason why the family relationship would factor it, would kind of intertwine with the financial desires in a case like this, because you can leverage the family relationship to keep the money coming.
I mean, I think that it's possible that that may be the case. I don't know that in this particular case, there's evidence that the gang members were motivated by her family in that way.
Well, then why did they tell her? Like the IJ credits this, and when they come to her, they say out loud what your colleague said is so unusual, that someone will actually say exactly what's on their mind in the middle of an extortion threat. But they say, like, we're here because we know about your husband and we know he's sending you money. I mean, doesn't that sort of indicate that this is part of the motive in this case? Why else mention it? Just like a pleasantry?
Well, I think that that again, it comes down to the substantial evidence standard and whether or not the record compels the conclusion that family was the motivating factor or was a motivating factor for the gang members, when if she had been getting that money from a charity or a trust account or an employer, the gang members arguably would have been just as motivated to target her.
But the fact is, she got the money from her husband, and they knew it.
The record makes clear that they were aware of the payments that were being made by her husband to her. Yes, that is an accurate statement.
And she testified to that, and the IJ said she's credible. We believe
that is correct. That is correct.
Do you acknowledge that
the finding? Go ahead, Judge. I'm sorry.
No, you go ahead, Judge.
No, I just wanted to. I'm just trying to understand it because the IJ made that finding, a but-for finding, that petitioner's husband being in the U.S. and sending money back, she would not likely have been targeted or threatened, but for that. And so I think that seems to satisfy the one central reason standard.
And I mean, I think our response would just be that that again, the record supports the conclusion that the agency reached, which is that the marital relationship wasn't the basis for the gang members' interest in her. The steady stream of money was the basis, and the marital relationship was incidental to that. And not.
And that might have been understandable before Hernandez, but you have the Hernandez case, which is seems to say the opposite.
Do you acknowledge that as well that these were death threats against the petitioner and her daughter?
I think the record makes clear that the petitioner and her daughter were threatened. Yes.
With death.
Yes, I think that is.
And are you familiar with the fact that one of your colleagues in an in-bank proceeding a few days ago before this court advised us that our death threat jurisprudence was out of control or something and ought to be straightened out?
I am not aware. I know that there was an en banc decision or hearing earlier this week. Was that Portillo Flores, maybe? Flores.
That's
Portillo?
right. In bank proceeding on Monday, and we
okay.
Our death threat course jurisprudence was criticized by the Attorney General's representative.
Okay. I think
you're not challenging our death threat course of jurisprudence.
I mean, I think in this particular case, the board's decision here turns on the issue of nexus, and not whether or not the threats rose to the level of persecution. I think when the board said, and this is on page 5 of the record, I think when the board said that economic extortion is not a recognized form of persecution, what they were referring to is that if it were economic extortion purely and there were no protected ground implicated, then that would be insufficient to qualify as persecution. But apart from that, I don't think this case turns on an insufficient past persecution finding. I think that the board assumed without deciding that the social group was cognizable, and then turned to the issue of whether or not there was a nexus in this case.
Counsel, I read the opinion the same way, but can I just ask you, in terms of the threats, so just assuming hypothetically that I thought there was a nexus established on this record, sort of normally we would just remand to the agency and let the agency, as you say, I didn't see that the agency has already addressed this question of whether the harm at issue rises to the level of persecution, and normally we would just remand on that. But I am trying to get a feel for if we do that, are we going to be back here again with the agency coming back to the Fourth Circuit and saying, we understand that under your jurisprudence, this would constitute persecution, these death threats, but we think that's all wrong and that you should reverse all of your cases? Should we go ahead and decide that issue now?
I think it's a very sort of hypothetical chain of events. I mean, I can see lots of different possible outcomes to this case if the court were to seek to remand it. And it's hard to know, whether the petitioner might introduce additional facts, whether the board might further remand to the immigration judge. It's hard to know what arguments would be made down the road on that. And I'm not familiar with what arguments were made in the en banc hearing regarding past persecution. If I can turn to the Convention Against Torture claim, that would just reiterate that claim was unexhausted, as it was not raised properly before the board. and further with respect to the petitioner's challenge to the sufficiency of the notice to appear that is foreclosed by this court's decision in United States versus Cortez. And as for the Lagos issue that the petitioner raised regarding the anti-gang political opinion, we addressed that in our brief on page 23. But essentially, this anti-gang political opinion claim was not one that was raised during petitioner's immigration court proceedings or in her appeal to the board. And we would respectfully argue waiver on that point. If the court has nothing further, we would respectfully ask that the court deny the petition for review and dismiss it to the extent that the petitioner has raised some unexhausted issues.
Thank you, Ms. Carter, very much.
Thank you.
Mr. Westrike?
Yes, Your Honor. I believe I reserved 5 minutes, although I think I may have used some of that initially. As my colleague just pointed,
go right ahead.
Thank you, Your Honor. As my colleague pointed out, the board did, on page 5 of the record, say economic extortion is not a recognized form of persecution, which I think is not the law in this circuit. And I did use the time to pull the Hernandez-Cartagena matter, and on page 10 of that ruling, the court wrote that the petitioner in that case demonstrated that her family was being targeted for extortive threats. Similarly here, it is the family that's being targeted. And I think that the combination of the Hernandez-Cartagena matter and the Lagos matter is the law that really should control here. While I'm not conceding the Pereira argument, I think that is my weaker argument. And I believe on the Convention Against Torture issue that the facts were raised below, and the Convention Against Torture was noted in the brief that counsel presented to the board. But I think unless the court has other questions, I have nothing further to add beyond that.
Very good. We appreciate it. Your case will be submitted. If we were in Richmond, we'd, of course, leave the bench and come down and shake hands with you. You did a good job as well. We'll do the same thing with Ms. Carter, but we have to defer that to your next appearance, hopefully in Richmond. Thank you very much.
Thank you, Your Honor. I appreciate the courtesy of you and your staff in organizing the remote appearance. Your staff has been very, very helpful.
Thanks again. And Madam Clerk, could you call the
Case number 20-1265, Columbia Insurance Company versus Christopher Camille Waymer.
Ms. Barnes?
Yes, Your Honor.
You
Good
out
afternoon.
there?
I'm out here. Can you all hear me?
Yes, ma'am.
Okay.
Good to have you with us.
Thank you very much. I'm Kathleen Barnes. I'm appearing today on behalf of the appellants, Mr. and Ms. Reynolds, and also appearing for appellant Mr. Waymer is Mr. Utsi, and we have agreed to split some of our initial argument time.
Okay.
I'll be arguing for the first 12 minutes, and Mr. Utsi will take 3 minutes after that. This appeal presents disputed issues for a jury to decide. I might say that repeatedly today. There's an issue for a jury to decide because pretty much every issue we're going to discuss is one as to which there is conflicting evidence. When it granted summary judgment, the district court misapplied the summary judgment standard by failing to view the evidence in a light most favorable to the appellants, and then ruling on bad faith and negligence as a matter of law. What we're asking this court to do is to properly view the evidence and inferences in a light most favorable to the appellants and find that there is conflicting evidence as to whether Columbia Insurance Company lacked a reasonable basis to reject both the January 23rd and the May 21st settlement demands. Because of that conflicting evidence, summary judgment was improper and this court should reverse. I'm going to start with the January.
All this depended on the deadlines that were arbitrarily fixed by the plaintiff's lawyers' demand letters, correct?
I disagree that they were arbitrary. The plaintiffs did set the
Well,
deadlines for time demand.
they weren't fixed by the court, and they weren't agreed to by the other side. You all just wrote a demand letter, or more than one, and said if you don't answer within 10 days or whatever the date was, then that's the end of it. That was, right?
Well, they said if you don't answer within that time frame, then we're not going to accept the policy limits. But that's, I mean, a time demand is allowed under Tiger River and all of its progeny in South Carolina.
I'm not saying you can't do it this way, but when you do it this way, you're just inviting the other lawyer to plant his feet too. You're stirring up a disagreement among counsel rather than really trying to get something settled.
Your Honor, I disagree with that.
We've all been lawyers too. A lot of us have been through this. And
Well,
it seems to me that the first time you wrote something to them, you gave them a deadline. Pay us the $1 million by such and such a date, or it's all over. We're going to get more than the policy limit.
Well, they did set a deadline, but they set a deadline for a reason. In this case, as to when, their clients at what point would have been willing to accept that, and for various reasons at what point they wouldn't have been, because it's clearly undisputed at this point that $1 million is nowhere near enough to cover their damages. And so there's a certain time frame at which they were willing to accept that, and a certain time frame at which they said, no, that's no longer enough for us to settle this case. I don't think there's anything inherently wrong with that proposition. A time demand inherently always says after a certain point, we're not going to take this much money. And here there were valid reasons for why they sent the letter when they did, and why they set the time frame for responding to it when they did.
So you've got a situation where you've got a very seasoned trial judge here looking at these kind of cases, very familiar with these kind of cases. And I'm just thinking in terms of where is this judge going in terms, particularly this first offer, that if it does meet the so-called obvious standard that everybody would know this case, that maybe the adjuster knew it was in excess of $1 million, why not you do it? Didn't have the medical records at the time, not all of them, didn't know the full extent of the cost, which many times that's where you can at least gauge damages based upon the cost of the medical damages. I don't know if the $62,000 was known at the time of the helicopter, but that's a helicopter ride, not really medical treatment, but it does indicate the seriousness of it. There's a lot of factors here. What I want, if you can answer in terms of our standard of review, typically in a summary judgment, we're looking for issues of fact. But this is a kind of an interesting situation because it really turns on whether, as a matter of law, can the court say that there is a reasonable basis for rejecting both settlements? And it looks to me as though that's what the judge did. The judge says, as a matter of law, there is a reason. And the reason is, as Judge King pointed out, you gave 10 days. And this is before you had the medical records, even though I guess they could have got them. I don't know how they get them in 10 days, what the process. But 10 days is mighty short. And, so what respond to that? I think that's kind of where I'm looking at, trying to figure out where was the trial judge going on this in ruling in this matter. And it seems like it was the 10 days, but it also was the fact that they needed a little time to investigate it. You got to pay out $1 million, even though, as you say, it looks like it's pretty obvious, but it's $1 million. And 10 days is a mighty short time to say, give me $1 million or you don't, we're not going to settle the case. How do you respond?
Well, Your Honor, starting with the 10 days part of it that you asked about, and I think as well Judge Gergel focused on, that's the incorrect time for when you start looking at their conduct. They have a duty to begin investigating this as soon as the claim comes to them. They ordered their independent adjuster on December the 19th to go ahead and ask for medical authorizations and start getting the medical records in this case. So their time for starting to investigate.
So before you throw me off on that, I want to make sure I understand that and what is the South Carolina law on it. You said they have a duty to investigate from day one, probably so, but the question is from the date of the offer, how long did they have in order to respond to this offer? If you follow what you're saying, you could come in with this offer the day before and give them 24 hours or 10 minutes if they've had 4 months to investigate it. And I'm not sure I'm following that logic at all.
Well, I'm not saying that simply because they have a duty to investigate from the beginning of a claim means that you can come in and make a time demand that will be deemed reasonable at any time. The point was simply that their duty to start investigating and getting these medical records doesn't start the day that they get the time demand. They were supposed to have been doing this all along. And in fact, the evidence here shows they turned down an offer of medical authorizations before this demand was even sent. So
Counsel, this is Judge Harris. Am I misremembering the record, which was confusing on this? I thought that even the Reynolds' lawyer was only getting partial records like the day before that 10-day thing expired. It seemed that no matter how soon you started, right, you were going to have to wait until after the Reynolds were out of the hospital, and then it was going to take 10 to 20 to 30 days. And even their own lawyer hadn't gotten complete records by the time this offer expired. Is that not right?
He had not gotten complete records by then, but he had also, I don't think he had asked for all of the full records by then. But that point, starting the analysis at that point assumes that they needed and as a matter of law were allowed or required to have those before they could ever respond to a demand. And that is inherently a jury issue. It's going to differ in every single case whether those medical records are necessary.
Really just a very basic sort of documentation of these injuries. It's not like they were looking for, we want to go back in time in your medical records to see if you had pre-existing conditions. We just want to know how much did it cost when you went to the hospital because of this accident. And you think there could be, assuming that there was no reasonable opportunity to get that substantiation for the cost of the medical care from the accident, it could still be bad faith to refuse to settle for $1 million?
Yes, Your Honor, I believe it could still be, it was not bad faith as a matter of law. Again, this is summary judgment. So all we're saying here is that there's conflicting evidence that a reasonable jury could find it wasn't reasonable. A jury could find it was. It's just conflicting evidence. Our biggest issue with the district court is that he decided these as a matter of law instead of submitting them to the jury.
Well, I guess I sort of gave you a hypothetical. But it's a hypothetical. If the facts are undisputed, that there is no way that this insurance company could have gotten substantiation in the form of hospital records just for the treatment of these injuries, the injuries caused by the accident, then it would still be a question for the jury whether it was bad faith for the insurance company not to pay out $1 million without any substantiation of these people's injuries, or the extent of the cost of treating those injuries.
Yes, Your Honor, if I understand correctly, if you put the fact in this case that there was no way they could have gotten the MUSC medical records before then, that's still a jury question whether they had enough information otherwise to conclude that the value of the claims was going to exceed the policy limits. But Judge Wynn, I'm not sure if I answered your question about this, I think, sort of being factual versus ruling as a matter of law, but I think I somewhat did in answering Judge Harris's questions. But if I haven't, please let me know, because I'd like to be sure I answer your concern.
Well, I think the posture of it, it being that the judge needed only found that as a matter of law, there is a basis upon which they could have made this decision to not doing it, as opposed to the usual summary judgment where you simply look for any disputed fact, or you try to determine, and maybe herein your point would be is that it is disputed as to whether or not this is obvious, or that and maybe a reasonable jury could find that there's no way you would not have done this under the facts of this case. Maybe that's where you're going, but I think the summary judgment aspect of it has an important role here, but I also think it's nuanced more than just the go find a disputed fact. But you can find one, but if outside of that fact there's a reason they could have done it, it seems like to me they prevail against the bad faith in this instance.
Well, Your Honor, that point of summary judgment in terms of getting to this medical record issue, and part of our problem is we felt like Judge Gergel just sort of skipped over some issues that you would have to decide before you got to whether or not, they needed the medical records or they didn't need the medical records in this situation. So, I mean, in deciding it as a matter of law, he really decided 3 or 4 disputed factual issues, whether they could or should have evaluated the claims without this. This is not a situation where they said, well, we don't think it's worth $1 million, but we'll pay you, 200,000. They refused to make any type of settlement offer whatsoever here. And I see.
Well, but I thought that was their whole point, that they didn't know how much to offer because they hadn't gotten the medical records. And I did think that the district court did address this. And now I'm working from memory, but I thought the district court said, look, yeah, there is some evidence. I mean, they built up the reserves to $1 million. It was obviously a horrific accident. People had to be airlifted to a hospital. It was a substantial hospital stay. So yeah, there was definitely some evidence to put the insurance company on notice that this was likely to be a very expensive payout. But I thought the district court said, still, and I agree with Judge Wynn, as a matter of law, an insurance company is entitled to get some substantiation. At least if it acts diligently, it's entitled to get some substantiation of the claims before it makes the payout.
I'm in excess of my initial time. May I answer your question?
Go
Yes,
ahead.
please.
I think you get to a very good point, which is he did say, yeah, there was some indication that it was going to exceed the policy limits. And at that point, they should have been on hyper alert that they needed to act in a manner that served their duties to their insured in this situation. If there were all these indicators that it was going to exceed $1 million and all they said was, well, we're pretty sure it's going to exceed $1 million, but we want these substantiating documents, that's a jury issue, whether it was reasonable to require that specific substantiation. All they've said here is, we wanted these specific records. It wasn't, we don't know if it's going to exceed $1 million. We need to finish our liability evaluation. None of these other things. It was, we want these things to document our file. And at that point, when they are on alert, as Judge Gergel said, that this claim is likely to exceed $1 million, is it worth it for them to say, we want to document our file to the risk that our insured is going to end up with an excess judgment? So thank you for letting me speak, and I'll give Mr. Utsi over to the argument and talk again in reply.
Thank you. Mr. Utsi, you out there?
Yes, sir. Good afternoon, and may it please the court. I represent the insured in this case, Christopher Waymer, and in the limited time I have reserved to speak, I'd like to address one of several aspects of this case that creates an issue of fact for the jury to resolve. And this is a different one than the panel's been discussing with Ms. Barnes. That is whether Columbia Insurance Company had a reasonable basis upon which to reject the May 21, 2014 settlement proposal from Mr. Tinsley.
Can I ask you a quick, I'm sorry, before you get into that, may I ask you a question about the relationship between these two settlements? Just assuming hypothetically, if I agreed with the district court that on the first settlement, if I agreed that on the first settlement, as a matter of law, no reasonable jury could find that the refusal of the January offer was in bad faith. If that were right, then I wouldn't have to reach the second settlement, right? Because now we're hypothesizing that in this high-low litigation, no reasonable jury could come back with a finding of bad faith. So the maximum payout would be the $1 million, which is what was paid out. So there'd be no injury or damage from rejecting that settlement, right? If the judge was right about the first settlement, then there's no injury from rejecting the second settlement. Isn't that right?
I don't think that's entirely correct, Judge Harris, and the reason is I don't think it's appropriate to dissect this entire sequence of events into individual pieces in that fashion. You have to contextualize each step. When you consider—
Well, no, but I'm saying even if they rejected the second settlement offer in bad faith, there'd be no damage from that. I don't know what you could recover for that, because we're now, again, just by hypothesis, assuming that the jury in that high-low litigation had to come back with a finding that there was no bad faith.
I think what you're getting to there, is there a causation issue that would tie the—
Right. There's no damages or cause from the bad faith refusal to take that second settlement.
Again, I think you have to go back to the sequence of events. If in fact you assume your proposition, with which we obviously disagree, that the
Of
initial.
course, and this is just hypothetical. I'm really
Sure.
just trying to figure out how this fits together.
If that rejection of the initial demand was in good faith, hypothetically,
Mm-hmm.
then you come not immediately from there to the May letter that I would like to discuss, but instead you have the interim offer, which was conditioned on not only a release of my client, or protection for my client, Mr. Waymer, but also a release of Columbia. It's that offer from Columbia that prompted the response from Mr. Tinsley in the May letter, because the important distinction between Columbia's proposal, where they wanted to have their own protection in addition to the protection of the insured, is what led to the May letter, in which Mr. Tinsley said, wait a minute, really all you have to give up is this insistence on being protected Columbia Insurance Company in order to protect your insured. And that's why the context shows that rejection of the May letter is, there's evidence of bad faith there. Unfortunately, because of our time constraints, I was only able to reserve 3 minutes, and so I see that my time has expired.
Thank you very much, Mr. Yutzi. Mr. Brown, are you out there?
Yes, Your Honor. May it please the court. The panel has been, thank you. Panel has been asking questions that I think are exactly the right questions. The first issue on the January offer is, could a reasonable jury find that CIC, which is Columbia, had no reasonable basis to decline the January offer? And as a matter of law, an insurance company has a right and a duty, actually, to investigate and get substantiating, corroborating records. We have cited in our briefing numerous decisions from various circuit courts that say that. One case I'll bring to your attention, especially, it's a Middle District of Florida, but it's very interesting in the way that they discuss it, the Noonan case. In that case, very similar facts. The reserves, in fact, were raised at the outset, almost a couple of days after the accident. This was an excess policy carrier. It's put on notice of the accident. They raised their reserves to the limits. The court had no problem saying, no, you don't have to do this time-limited demand without any substantiating records. The court noted that this Tiger River bad faith duty to reasonably settle is a shield for insureds. It is not a sword for claimants' lawyers. And the claimant cannot, by using this technique of a time-limited demand, take away the insurance company's rights to justify and substantiate the claim that it's supposed to pay. A contrary rule would just encourage fraud. It would encourage sending very short demands, as Judge Wynn was pointing out, with only partial information, and then you get to go to a jury in accordance with what Ms. Barnes was saying, and you get to argue, well, this is enough information. Well, that's enough information. And under their May offer scenario that the plaintiff lawyers engaged in, you would then be faced with, I could see an insurance company be faced with several staggered demands. You have to agree to a high of $5 million, and then that's a question for the jury. You have to agree to a high of $4 million. That's going to be a question for the jury. I mean, this would go on and on. And so for the January offer, the district judge made the very unremarkable ruling, which is supported by numerous circuit courts, which we cite in our brief, that the insurance company is entitled to get substantiating records and corroborating records before it pays certainly $1 million out. And the only thing they had at the time was the air ambulance records and bills, and that was it. The argument is made by counsel that, well, you got to look at the first date of when they first started investigating and go by that, and somehow it's somehow bad faith anyway. And I think the panel has asked two excellent questions, which I had written down already to talk about. One is there's no causation here. Even if you were going to complain about Mr. Ray, assuming it's all true that he didn't, that on the phone, a paralegal for the plaintiff's lawyer said, please accept medical authorizations. And he said, I don't need them. Assume that's true. It didn't matter because that was on January 9th. The Reynolds were still in the hospital. No one could get the records.
Let's explore at least in terms of the first offer.
Yes.
And it just seems, I mean, it's hard not to think about the days when I practiced law. And if I knew that a tractor trailer hit a car with two people in it, and it totaled that car, and you had to take a helicopter and take the husband and wife to a medical facility that would cost over $60,000 to send that, and they each stay there in excess of, I guess, 3 weeks or more, I would pretty much bet anybody that case was worth $1 million. And I think Mr. Ray thought that too when he was looking at this, saying, that's $1 million. We might want to just pay this and take a walk. And so, I mean, there are cases in South Carolina when we're looking at the South Carolina law here, and maybe cases in which there have been death, but the case in which sometimes the damages in a case of this sort can be even greater than a death case because of the economic ongoing situation where you're living with certain conditions and medical bills are going to last. I mean, it wouldn't have taken much if you knew that your liability could be much more than $1 million. In other words, if you were in fact the insured here, rather than the insurer with $1 million, and you were looking at this thing and you knew you could end up with a verdict far in excess of $1 million. If I was in a position of the insurance company and I'm just thinking a reasonable this $1 million and get this over, or take a risk, and just kick it to the can and say, well, we're not worried about it because, we're not going to be found with bad faith. I mean, how is that not relevant in this case, that when we're looking at a question that the jury can find, even when you are looking at the prospect that a reasonable jury could or could not find that you didn't have a reason, but when you're looking at that reason, you got to look at the facts. You says, wait a minute, no reasonable insurance company would do this, not with all this, and really not come back and talk to you immediately about this $1 million, whether you're going to pay it or not. You will begin to make some serious inquiry. You see where I'm going with this?
I see where you're going, Judge. Let me respond this way. The law does not require anyone to pay money based on speculation. Okay?
Yeah, but I want to make sure we cover that point. There's no South Carolina authority that I've seen that says you are entitled to some substantiating records before you consider a settlement request. I mean, there's nothing that says that. And that's what we're dealing with. And you got to make a reasonable determination. It's a conflict in a sense because you got $1 million insurance company, and then you got a guy you actually insured over there shaking in his boots saying, whoa, this could be a whole lot more than $1 million. So, the incentive is sort of skewed here, but we've got to look at the reality. Yeah, you would like to have had the $600,000 in medical bills and that sort of stuff, but I'm just telling you, not many people are going to look at a tractor trailer hitting a car like this and this kind of damage and these people with these injuries, and I say, oh, even in South Carolina, this is worth $1 million.
Judge, I think you would be requiring, first of all, I can't cite a South Carolina case that says you can't get substantiating records. I can cite some cases.
No, don't misinterpret what I said. I didn't say you can't get them. I said it wasn't saying you were entitled to get those before you take some action. That's what I'm saying. And the cases cited by the district court here are all out of circuit cases.
Well, Your Honor, you're entitled as a carrier to investigate, okay, and to get the corroborating information before you pay the $1 million There are South Carolina cases that say you have a right of investigation. You do not have to guess that the hospital, all the hospitalization and all the time they spend in there was in fact.
And I'm gonna turn it loose because I think we're sort of getting to the point where we're understanding one another. I'm not disagreeing with a thing you just said, but what I am saying to you is that there are cases in South Carolina, if it is obvious, or it approaches a situation where a reasonable jury could determine it's obvious, you got an expert who testifies to you that it is a foregone conclusion. This thing is over $1 million. And when you look at all these facts that are put there, and I don't know where the expert, I mean, do you go to other lawyers who have these cases that are around? I'm pretty sure they will look at this. I don't think you could find one who felt like they knew what they were doing. This case wasn't worth $1 million within a few days of this thing happening, understanding the nature of it. So it's not like they just said, you know, give us $1 million and nothing. You knew a lot of stuff here. So that's what you were sort of jumping over, is what you knew. And you can have an opinion that what you knew was not enough to make that determination, but I'm having a hard time getting there on that one.
Well, Judge, there are cases, and I mentioned this to Judge Gergel at the hearing. I can't remember which case it was, but there was one where someone got airlifted and out of an accident scene, and they walked away from the hospital the very next day. Okay, somebody can go to a hospital and they can end up staying in there because they had contracted COVID before the accident happened, and they had to be treated for COVID for 2 months. I mean, we don't know until we get the corroborating information, and you can't set a rule, Judge, in all the respect, that says, well, you're going to have to just take the risk of a jury trial on that question each and every time, because that will engender and foster this exact type of cat and mouse game that the Noonan court and all these other courts that we cited at page 2 of our brief, or on our brief, excuse me.
What did you do during that 10 days? What did you do? What actually was done once you did receive some material from the lawyer? You knew of the accident. You had an investigator who had gone to it. So I'm trying to determine in that 10 days, what did you do? And put it in the context of, you know, things that could have been done. But I also want you to view it not just in terms of the people who were injured. It's really the insured. He's over there shaking in his boots that you're not going to do anything on this case. And what do you do during this 10 days? I'm sure you must have run around trying to help him like crazy to find out, you know, if you had to pay it out. Tell me what did the insurance company actually do during those 10 days?
Okay. Your Honor, the insurance company immediately assigned an investigator. That investigator began the process of gathering facts. The investigator and ultimately also within this time period of the time limited demand, a lawyer actually met with Mr. Waymer. And let's talk about the insured for a minute. The insured, Mr. Waymer, who is described as a dropped out of 10th grade person, didn't have an ability to understand things by plaintiff's counsel in a deposition. This gentleman didn't think he was responsible for this accident. Okay? When he felt like this was really not his fault, is the way he approached it.
That's not an issue in this case because you're very clear from the beginning who was responsible for this accident. He can think what he want to think. You knew that right from the beginning. You were going to have to pay some money. So that's irrelevant, whether he's got a 10th grade education or not. In fact, it weighs in his favor. It tells me you ought to have been really working to help him because this guy doesn't get it. He doesn't understand if this thing is over $1 billion, oh, that's on him. That's where I see that going.
Well, I understand that viewpoint, Your Honor, but it was made apparent in every single one of the activity reports of the investigator in this case. And you can look back at every page of it. He was trying to get the official police report from day one about this, okay? He never got it until February the 25th, well after this 10-day time limit demand expired, okay? So there was a question of comparative fault. This is a person who drove into the very rear end portion of the trailer and almost gotten across the intersection that had reflective light tape all over it. Mr. Reynolds, who drove into the back of that trailer as it was crossing the intersection, he had a clear line of sight. He was estimated to be going 60 miles an hour at the time of impact. The speed limit was 60 miles an hour. Mr. Tinsley testified in his deposition that Mr. Reynolds applied the brakes at the time of the accident. So therefore, Mr. Reynolds.
So are you saying that for the most part, your concern was more so about the issue of liability rather than damages?
No, Your Honor.
Because I want to be clear that you had an adjuster on this thing from the beginning. That adjuster looked like to me, he threw up his hand pretty quickly and says, "Whoa, we need to pay this." So I mean, what did the adjuster do? I mean, you got an investigator. Well, I mean, I don't get it. I mean, if it's a question of liability, I'm not sure I'm seeing that in the record, but I'll go back and give you the benefit of the doubt and really look at that issue, because I thought it was more of a question of you didn't have enough information to assess the damages of it.
Well, Your Honor, there were two issues going on, okay? There's no question that primarily it was the medical records, okay? But there was also a question of comparative fault on Mr. Reynolds, or whether this accident was Mr. Reynolds' fault and not Mr. Waymer. And Mr. Waymer felt like it really wasn't his fault. And so, you know, when we meet with our insured, he's saying, I don't really think this is my fault. And we are trying to get the police report. We are trying to get the medical records ultimately that Mr. Salibi is, that's the other thing that happened, Judge, is this thing got escalated up in the company to David Dick, who was an attorney at the insurance company. And he, in turn, on January the 10th, retained counsel. This was before any kind of lawsuit or anything else. So they were treating this very seriously. They retained counsel. Ultimately, there was a meeting that one of the lawyers had with Mr. Waymer about the accident scene. And they ultimately went about trying to get the medical records, as we've already been through. And in order to pay $1 million, you should not have to, and you don't have to guess or speculate about, well, it's probably liability and it's probably $1 million in damages. You just don't. You're allowed, as a matter of law, to get some substantiating information, and the plaintiff's lawyer is not allowed to alter your rights in your contract with your insured by using this artifice, this 10-day limited demand technique. That is a very dangerous rule to allow this and to foster this type of thing. You're going to create, this will be coming up to your court quite often if this is allowed to get, you know, well, the insurance company's got some information on this. Let's just make the short, you know, I think as you said, Judge Wynn, 10-minute demand. I mean, you got this information, give me the money in 10 minutes. And it's a jury question about whether that's reasonable. That's what you're going to be getting. And the courts in the 9th Circuit, the 11th Circuit, California, Florida, Kansas, Georgia, all of those cases have said, no. The insurance company, as a matter of law, has a right to get substantiating, corroborating records before they have to pay it out. And the Georgia court also, the Baker versus Huff case, which I would commend to the court, also, by coincidence, mentioned that there was a plaintiff expert in there who was saying, yeah, they had enough information to make the decision. And the court said, look, we're not going to allow a plaintiff expert to create a jury question on this. You're allowed to get substantiating, corroborating information before you have to pay your money. And there is here's a really important point in this case. No one is arguing that once the insurance company got the information, okay, in early April, that they did anything dilatory. In fact, the judge found that they acted in warp speed fashion on the review of those materials and offering them $1 million. I think it's 25 days.
Counsel, this is Judge Harris. I was going to ask you about that. The district court did at least talk about that. And can we look at what happened after the settlement was refused and considering whether the refusal itself was reasonable? That's okay?
Well, what I think I'm doing there, Your Honor, is I'm just pointing out that, and it goes to the May question as well. But I'm just pointing out that no one is saying that once the insurance company received the totality information that they didn't act promptly. Okay, that is not in dispute. No one is arguing that. So I agree with you that when you assess the January offer, what you do is you look at what information did they have at that time, and did anything occur that is their fault that deprived them of a reasonable basis for not paying $1 million? The answer is no. As you already pointed out, Judge Harris, there was no causative action by anybody associated with Columbia Insurance Company that prevented them from getting the records in time to meet this time limit demand. This was an artificial demand. Judge King said this. He's correct. And I want to make this point, Your Honor, if I could, in the limited time I have. The whole reason that the plaintiff's lawyer argues that he needed this time limit demand is because he didn't want to get this medical lien letter in his file, okay? But the reason he got a medical lien letter in his file is because he asked for the records on December the 30th. So he started this clock running way back on December the 30th. And if anybody's going to be blamed for him getting a medical lien letter, it's him. He's the one that asked for the records first. He only asked for partial records, but he nevertheless asked for those. And he set that clock in motion for himself. Then he decided on his own arbitrarily to put 10 days in there. His secretary came in and gave him a draft letter that had 20 days. He scratched through it and wrote 10 days. And this is all a claimant trying to impact the rights of the insurance company and its insured in an improper manner. And the same is true with the May offer. They cannot make the insurance company do things that are not within its insurance policy rights through these settlement offer mechanisms. That's just not appropriate. I'm out of time. I'll answer any further questions, but the district judge should be affirmed with all due respect. Thank you.
Thank you very much, Mr. Brown. Ms. Barnes?
Excuse me, I forgot to unmute. The first point that I would like to make in reply is to respond to this repeated statement that Mr. Brown made that they have a right as a matter of law to get substantiating information. And I think, as Judge Wynn pointed out, there is no South Carolina case that says that whatsoever. And I think the two cases that we cited in our brief actually say the opposite. The Varnador versus Nationwide Mutual Insurance case and Howard versus State Farm, the one from South Carolina, not from the district court. Both of those basically say that the insured is not bound to the insurance company's investigation. And Varnador went so far as to say, you can't bind the insured to that investigation. You'd be insulating an insurer from liability and foreclosing jury consideration of an insured's evidence of bad faith. So I just want to go ahead and dispel that notion that that exists as a matter of law in South Carolina, because the law is actually to the contrary. As to this discussion, that there was some discussion about liability and comparative fault, that was not a basis for their rejection, as I think Judge Wynn pointed out. They knew by January the 16th, Mr. Ray reported to Columbia Insurance Company that he had talked to the officer, that the officer said Mr. Waymer was clearly at fault. He violated a statute which implicated punitive damages at that point, and recommended that they pay the property damage. And Mr. Fay, the appellant's expert, said Once he recommended property damage, that's the same thing as saying our insured is liable here. And Columbia Insurance Company, in violation of industry standards and a South Carolina statute, said we're not going to pay the property damage claim because we think we're going to need to save all the money we can for the bodily injury limits there.
Well, it's a whole lot different between that property damage claim and what ultimately the $1 million. But now, are you, insofar as the rejection by the insurance company, are you speaking to the first offer as well as the second one? Or did they in fact reject the first one? And I'm just slipping on my mind right now because we've got a number of cases coming together, but refresh my recollection. Did they reject the first one? Or did they just let the 10 days expire?
They let the 10 days expire. So the only communication that happened after the offer was made was that the lawyer for Mr. Waymer made contact and said, we don't have the MUSC medical records. We need those to evaluate the claims. And they were sent medical authorizations that day, and then there was no further communication. They didn't ask for an extension of it.
Let me ask you, because we're dealing with South Carolina law, and there's a lot of prediction as to what South Carolina would do. I mean, there's always the issue of whether or not we need to certify some of this to the South Carolina Supreme Court, but I'm not going there. But I'm curious as to your position, and you did mention it, that if they are presented with an offer with a 10-day period, is there most people, if they feel like they are kind of in a situation, they would at least make some overture and says, can you extend the 10 days? Lawyers do it all the time. Was any of that done here?
No, Your Honor, it was not done. And I will say, actually, we contend that it was 14 days, not 10. But no, they never asked for an extension in
let's
this
assume
case.
it's not much difference between 14 and 10, so we won't get hung up on that one. But I'm more curious in terms of whether there's any case law or anything from South Carolina specifically that address that concern, that when you are, because it outside of the fact that, perhaps the insured did have a 10th grade education, which again, from my perspective, kind of makes it more of an uneven situation from my perspective with the insurer. Sure, the person who's actually insuring them, it just seems to me if this person is about to face some greater degree of liability, and you're coming up on the 10 days and you haven't had a chance to investigate, it just seems reasonable you to reach out to the lawyer and says, look here, I can't get this thing together within 10 days. Can you give me another week or a couple weeks or something to work with it? And we need something here to just do it. We want to work with you. Any of that done here?
No, Your Honor, that was not done here. And as I pointed out, I think initially.
But is any of it required? Now I don't want to just cabin that as to say that's bad, but does the South Carolina law point it in the direction that something like that would be a basis for saying you did not engage in this transaction with good faith, or you did so in bad faith? Is there any case that would point out to give us some guidance of what South Carolina would say on that?
I know my time has expired. If I may answer your question.
You go ahead and answer Judge Wynn's questions.
Yeah, just give it a case. If you don't have a case, just say, I don't know of one.
I don't know of one that's directly on point with those facts, but my response would be that they have a duty to do what's in the best interest of their insured. And what's in the best interest of their insured is to have properly investigated this from the beginning and not to put their need to document their file above the duty that they owe to their insured. If that answers your question.
Thank you.
Thank you very much, Ms. Barnes.
Thank you.
We appreciate it. And we would come down and greet the lawyers if we were at Richmond, but we can't do it. So we'll just have to say thank you and wish you all the best. We'll take your matter on this case under advisement. Judge Wynn, Judge Harris, either of you need a break?
I'm at your pleasure.
Yes, sir. Number 2021-76, Virginia Hospital and Healthcare Association versus Karen Kimsey.
Mr. Kimberly?
Good afternoon, Your Honor. My name is Michael Kimberly, and I represent the appellants in this case. Your Honors, I'd like to begin with a clarification that I think is pretty crucial to our takings claim. A successful takings claim has two elements. First, a taking of private property for public use, and then second, and analytically distinct, a denial of just compensation for that taking. The Supreme Court's decisions in Nick and Monsanto both confirm that the Fifth Amendment forbids only the denial of just compensation after a taking has occurred, and it doesn't forbid the taking itself. So those cases both hold that an injunction barring a taking from occurring generally will be inappropriate when a damages remedy, which is to say just compensation, is available in a suited law. But that reasoning doesn't...
Are we clear at this point that your action arises under Section 1983 and not under the Supremacy Clause?
Yes, Your Honor. I think that's
Okay.
that's certainly true of the takings claim. I think it's true of the preemption claim as well. As to the takings claim, which is a constitutional claim arising under 1983, we are not seeking an injunction against the taking, which is what the Supreme Court was concerned about in Nick and Monsanto. Rather, we're asking for an injunction against a state law that systematically denies just compensation for the taking. So in other words...
Counsel, so this is your theory that EMTALA is the taking, and you're not trying to enjoin that. You're just trying to enjoin these state budget items?
That's correct, Your Honor.
Okay, but then why are you suing Virginia? If the federal government, EMTALA is a federal mandate, a federal statute, why does Virginia, it just seems to me like you might be suing the wrong defendant. You can't kind of mix and match your sovereigns that way, can you?
Well, I think in the Medicaid context, I wouldn't call it mixing and matching, but although EMTALA is a federal statute, DMAS is the appropriate defendant. And it's because when a statute like EMTALA takes private property from doctors and hospitals for public use, as it does, doctors and hospitals are entitled to just compensation. And when the patient who is receiving the EMTALA mandated care is covered by Medicaid, that compensation is determined and provided through a program, through the Medicaid program itself, which is administered jointly by state and federal authorities. I would add that the money...
So fine. So sue the federal government and say that your joint operation with Virginia isn't giving us back what you took from us with EMTALA. And it seemed like the 11th Circuit addressed this in that Baker case, and they said you can't do this. If it's the federal government, or I think it was the state government, that is requiring the care, you can't sue the other sovereign for failure to provide the just compensation.
Well, what I would say, Your Honor, is that Medicaid is really the quintessential example of cooperative federalism. It is a program that is administered by both state and federal authorities working together. I think the appropriate...
Is it both state and federal money involved? That's correct, isn't it?
That is true, Your Honor. A majority of the money used to fund Virginia's Medicaid program is federal money, but it is, as part of the joint program, the cooperative nature of the program, it is funded jointly by state and federal authorities.
The state has to put up a certain percentage of it.
That's exactly right.
And they passed these state statutes to save state money.
To save state and federal money, yes, Your Honor. To save money for the Medicaid program in Virginia overall, funded by both, and
by paying less for emergency room visits.
That's exactly right.
You say there that it said it was passed over the veto of the governor. They had a special session to do that.
Your Honor, it was part of a special session, and this was an artifact of the pandemic. It was a special session that had come together to override certain vetoes that had taken place, but the legislature undertook an emergency budget measure that included the budget items at that time.
Okay, but now they required these. You say they required the downcoding provision requires them to judge the the delivery of services based on the diagnosis.
That's
rather
correct.
Rather than what's the term when they go in? The other term?
Symptoms. It's symptoms versus diagnosis.
Symptoms versus diagnosis. And you say the federal code requires them to be judged on the symptoms. Now the state law says it can be on the diagnosis, which means they can pay less.
That is true, Your Honor.
If my wife thinks I'm having a heart attack and takes me down there and they decide I don't have a heart attack, then they down code and based it on the symptoms, right?
Well, they do, Your Honor. I want to be clear, though, that this statute is not purporting to carve out presentations that aren't truly emergencies. What it's doing instead is making a policy judgment that some emergency conditions really are preventable and would be better treated earlier on with preventive care. But once a patient...
Well, everybody would agree with that, wouldn't they? Nobody disagrees with that.
No, of course that's true. Although the point from the perspective of doctors and hospitals dealing with emergency room patients is whether or not it would be preferable that the condition were avoided with preventive care. Once an individual presents in the emergency room, the doctor and hospital are bound to provide the emergency care. And so this isn't a circumstance.
But they're also bound by federal law to make the records reflect correctly what they're supposed to reflect.
Well, that's exactly right, and that's precisely what's problematic with the budget.
What jumped off the page with me with this state statute is it seems to me like they're mandating the falsification of records.
Your Honor, that's a point that we made in our reply brief, and I think the way that the state is approaching its description of the way this program works is exactly that. And of course, if that's what we're going on, and there were falsification of records going on, we wouldn't be here suing to defend the conduct of our doctors and hospitals. I do want to be sure to come back, if I may, to Judge Harris's question, because I think it's an important one. In the context of a joint program like this, really the question is who bears the responsibility to furnish just compensation? The fact that this is a joint program doesn't absolve the state government entity, which is effectively playing the role of agent on behalf of the federal government insofar as it's allocating federal dollars.
Counsel, I guess I think I sort of understand what you're saying, but it does seem to me like this is sort of an issue for your case, the two different entities here, and I don't see any of this in your complaint. I think that the district court thought, and I understand why the district court thought this based on your complaint, that you were saying that the taking was affected by these Virginia reimbursement rates, that you had an investment-backed expectation that gave rise to a property interest in the reimbursement rates themselves. And then the district court just said, well, you can't enjoin that, as we all agree, you can't enjoin the taking itself, so you can't get an injunction. And I don't really see the part in your complaint where you explain all of this. No, EMTALA is the taking. We're not trying to enjoin that. We're trying to enjoin the state of Virginia for not reimbursing us or compensating us for a taking that has been effectuated by the federal government. And that might sound weird, district court, but let me explain to you why in the context of this joint partnership, we actually have the right defendant. I feel as though we're getting some of this for the first time on appeal.
Your Honor,
and in fact, why we even, yeah, go ahead.
That is assuredly not the case. And I don't have a pin site at the moment, but I will in the time that I have between now and my rebuttal get the pin sites. It was raised both in the briefing on the preliminary injunction and in the motion to dismiss. And it was the topic of extensive discussion at the oral argument. So there's no question. This is the theory that was before the judge. We made very, very clear that our position was not that we had a property right in the reimbursements ourselves. Our position was consistent with the Ninth Circuit's decision in Sierra Medical that our property right is the right in our in doctors and hospitals, real property in the professional services and the supplies that they use in these encounters, and that the taking is happening because DMAS is taking, in effect, level 4 services, but reimbursing only that portion that corresponds with a much, much less intensive level 1 service. Level 4 services would include presentations like heart failure or blood in the urine, severe acute asthma. These are all serious conditions requiring significant professional time, testing.
Counsel, I'm sorry, I'm looking at your brief, which explains that the budget items have the character of an unconstitutional taking because the budget items interfere with your investment-backed expectations and your property interests. And I mean, you'll get me the pin sites. I don't want to belabor the point.
Yeah, and Your Honor, I'll acknowledge that some of the earlier briefing was a little bit imprecise at times in describing what was the taking and what was the denial of just compensation. And candidly, it's because many of the cases themselves often allied those two elements, and it's why I started out with the clarification about the analytical distinction between the two. But as I say, I'll get you those pin sites to make clear that, as I say, this was the theory that we were arguing before the district court. I do, along these same lines, want to be clear that we stipulate for purposes of this lawsuit that the standard reimbursement rates set by DMAS for particular services represent just compensation. This case is not about just below cost reimbursements. And DMAS really can't disagree with this position because, of course, they're the ones who set the standard rates and determine that those rates are sufficient and reasonable to reimburse the service. So our point is only that once DMAS has determined what a reasonable just compensation—
You've got a lot of acronyms running around this case. DMAS is Virginia.
That's right. DMAS is the Virginia agency that administers the Virginia Medicaid program. I can call it the state if that's easier, Your Honor. Everybody throws these acronyms around. We get them all the time in these cases. It's hard to keep them straight. I understand, Your Honor, and I'll reduce my
Yeah, that's all right.
So our point is only that once the state has determined what reasonable compensation is for a legally mandated care, it must actually give that level of compensation. It can't pretend counterfactually that the services furnished were different, that they were less complex or less expensive.
And federal law requires that. Is that what you're saying?
And federal law requires that, Your Honor. That's
and federal law requires that. The federal law that requires that is statutory law and regulations.
That's correct, Your Honor. It's both EMTALA itself and the prudent layperson standard embodied in EMTALA, and it's also U2B2, Section 1396 U2B2, which provides that state Medicaid agencies must ensure, quote, shall require coverage for emergency services, where in turn emergency services is defined to mean the services needed to evaluate and stabilize an emergency medical condition, which in turn is defined according to the prudent layperson standard, which, as Your Honor mentioned earlier, is defined entirely based on presenting symptoms and not diagnoses. And you're claiming that the Virginia legislature has repealed the federal part of the federal code and the federal regulations. Superseded. That's correct, Your Honor. That the downcoding.
And that's how you get into claiming that the supremacy clause is triggered.
Well, I wouldn't say that it's a claim that arises under the supremacy clause. It implicates the supremacy clause in the sense that any preemption claim ultimately turns conceptually on the supremacy clause. But I think after Anderson, it's clear that this is a 1983 action.
Let me ask a question. If we do reach the merits of this whole taking, the merits of taking, what kind of taking do you say this is? Is it a physical taking or per se regulatory taking, or what bucket you say this is in?
Yeah, I think it's a per se regulatory taking and also a physical taking. The per se regulatory taking follows from the permanent invasion on real property and improvements, and I think also from the taking of professional services. You know, if a physician sells her knowledge and skill and time, just like a manufacturer sells widgets. It would be a per se taking to take the widgets. It's a per se taking to take a physician's professional services as well. Your Honor, I see I'm out of time. I'm happy to come back in rebuttal.
Thank you, Mr. Kimberly. You've saved rebuttal time. Ms. Kalen?
Good afternoon, Your Honors, and may it please the court, Michelle Callan for Karen Kimsey. Before jumping into the weeds, Your Honors, can you hear me all right?
Now I'm taking more of your time. I'm sorry.
Certainly, Your Honor. If folks are having trouble hearing me, just let me know and I'll adjust, but I'll continue on unless I hear that folks are having trouble hearing me. Before jumping into the weeds, I think it's important at the onset to clarify what this program does and what it does not do. First, all Virginia has done here is announce that going forward for treatments that take place after July 1st, 2020, Virginia's Department of Medical Assistance Services, DMAS, will reimburse certain emergency room services differently under Medicaid and will reimburse differently certain hospital readmissions. That is, if someone with conjunctivitis walks into the emergency room and receives an MRI, a CT scan, and sees 5 different experts, and the hospital bills this out for level 4 reimbursement under Medicaid, the hospital will receive level 1 reimbursement. So Virginia has not announced that it will decline Medicaid reimbursement altogether, nor has it enacted any retroactive policy. It simply announced that it will reimburse services after July 1st, 2020 at a different Medicaid rate. Second, this is not about denying anyone service or falsifying any records. It is about better matching the reimbursement to meeting a patient's actual need. No one is being turned away from treatment, and standards of care still assure that people with emergency needs receive emergency care. This program is simply about assuring that people who are better treated outside the emergency setting receive the more appropriate treatment, such as a primary care provider. Finally, even if we are wrong about all of this, the trade associations have the recourse that Congress created for them. If CMS, the federal agency tasked by Congress to administer Medicaid, concludes that we are wrong, it can deny the proposed amendments to Virginia's state plan. And if a state still does not comply, the HHS secretary can withhold Medicaid funding. If CMS approves the amendments to Virginia's state plan, then the trade associations if they disagree with CMS's conclusion, they have recourse under the APA, as the Supreme Court explained in Douglas. All parties to this case recognize that there is a problem with overutilization of emergency rooms. They merely disagree about the right policy for addressing that problem. But the Takings Clause is not a vehicle for private litigation over healthcare policy. Delving into the Takings Clause, the framing of the trade association's case is premised on a fundamental misunderstanding of the Takings Clause and how it works. Unlike the due process or equal protection clauses, the Takings Clause does not protect people against certain activity. That is, it does not protect people against the taking itself. It simply entitles certain people to just compensation for a taking. That is why, in general, claims for injunctive relief are not properly brought as takings claims. The appropriate relief for a takings claim
Are you all applying the prudent layperson standard in Virginia since July 1st?
Yes, we are not violating the prudent layperson standard, but I think the operative point with regard to the
You're not violating it. You're downcoding from the prudent layperson standard, correct?
No, Your Honor. The prudent layperson standard. So I think as an initial matter, in order to even get to the prudent layperson standard, there has to be, a right established, to set the stage for the cause of action here. And for all the reasons we lay out in our brief, that's not the case. But I think, CMS is the entity tasked by Congress to evaluate whether or not a state's proposed plan violates the prudent layperson standard here. And what the plaintiffs here ask this court to do is jump in front of CMS before that evaluation. But our view is—
Can I ask you, Counsel, this is Judge Harris, can I add this? You've alluded several times to the fact that CMS hasn't yet decided whether to approve this. and I think you suggest in your brief that maybe someone should be holding this in abeyance. Were we to get this far in the analysis, that before reaching the merits of the preemption claim, we should hold this in abeyance? Is that us, the district court? Are you saying it's not ripe, or just that we could decide it, but we shouldn't? I don't quite understand what you want us to do with this pending CMS approval factor.
Certainly, Your Honor. I think holding the case in abeyance is an option. And I think the
And what's the
discussion.
CMS mean? That's another one of those acronyms that get thrown around. See, that's a federal agency or a federal committee or something, right?
That's correct, Your Honor. It's the Federal Center for, I'm getting the exact.
Yeah, you don't know what it is either. I can't keep up with it. I'm glad to know that you all can't keep up with it either.
It's the Centers for.
It's the entity of the federal government that's supposed to decide whether what the state's doing in this Medicaid program is permissible under federal law.
That's correct, Your Honor.
And what you all have done in the legislature, effective 1 July, is presently pending before the CMS.
That's correct, Your Honor.
Well, why don't you all wait until they decide it?
We would be certainly fine with waiting until that's decided, Your Honor.
Well, why don't you agree, then will you agree right now to hold these changes in abeyance pending resolution of this by CMS?
No, Your Honor, we would certainly agree to hold the case in abeyance. But the way
you're applying your changes effective 1 July 2020. So they've been in effect for 8 months. That's what the other side's complaining about. And the doctors in the hospital aren't. They say they're not getting paid what they're supposed to getting paid, and therefore there's a taking of their work. The doctors in the hospitals aren't getting paid what they think they should be getting paid because you all are applying this down coding provision, for example.
And they have.
And that's costing them. That's a taking of their earnings, and that has appealed to me. I remember when we had a problem in West Virginia when I was a lawyer years and years ago. We had a system, and I won't charge you for this time for listening to me. We had a system where they paid court-appointed lawyers $50 for a felony case, period. If you went to trial for a week or 2 weeks, you got $50. And a lot of us did it. Everybody had to take the appointments, and we got $50. The Supreme Court of West Virginia ruled in favor of a challenge that violated the takings clause, lo and behold. That was the work product of the lawyers being taken for nothing, for $50. And they had to come up with another plan for court-appointed lawyers, and they had to pay them by the hour, and they had to pay them some expenses, and they had to give them some opportunities to hire experts and things like that. But anyway, in studying this case, I immediately thought of that. These doctors in the emergency room, they say you're taking their property, their services. That's what the claim is, as I understand it. And CMS is supposed to be looking at this thing now and trying to figure it out, and they haven't decided it yet. And but you say you'd be willing to hold it in abeyance, but you won't hold it in abeyance. Anyway, I'm going to say I won't charge you for that time, but you go ahead and answer Judge Harris's question there.
Certainly, Your Honor. So just a clarification. I think just to clarify that that we think is properly held in abeyance is the case, Your Honor. In terms of the way that the approval typically works with CMS is that CMS does not have to approve the plan in order for it to take effect. And I think if the court looks at the analysis in the Douglas case, that highlights precisely how these sorts of plan amendments take place. And I apologize to the court, but Judge Harris, I do not recall your precise question to answer.
Oh, it's fine. It's fine. But can I ask you to go back on this takings thing? So as I understand your colleague, what they're saying is, you know, the taking is effectuated by EMTALA, and we know we can't seek to enjoin the taking itself, and we're not trying to do that. Our claim is just about the just compensation, the state law provision that denies us just compensation, and so that's what we would like to enjoin. And there's nothing in Nick or any other case that says we can't enjoin that. So why is that not right?
I think that's not right on two fronts, Your Honor. First, just kind of the way takings claims work and the appropriate relief. And then second, the precise taking theory. So delving into the first point, unlike the due process clause or the equal protection clause, the taking clause does not protect people against certain activity, that it does not protect them against the taking itself. It simply entitles them to just compensation. And the Supreme Court did nothing in Nick to displace the longstanding rule that the determination of what constitutes just compensation should be made by the sovereign who enacted the taking in the first place. So it's both a question of, you know, the proper place, and federal courts are not the proper place. But Nick was also clear that as long as just compensation remedies are available, injunctive relief will be foreclosed. So I think the idea of an injunction in the context of a taking itself is simply a mismatch here. But even indulging in their takings theory, the trade association's framing of the case is fatally flawed. First, it's well established that the trade associations cannot premise a takings claim on voluntary participation in a federal program such as Medicaid or Medicare. And then second, the trade association's own theory is that EMTALA is the entity that enacts the actual taking.
I thought public hospitals have to participate, don't they? Public hospital. They have to participate, and they have to run emergency rooms, and they have to provide services, and doctors have to do it as part of their oath. They have to provide services, whether they get paid or not.
So I think it becomes a question of
talking about.
Yeah, so I think that under the arguments raised in the briefing by the trade association is that it's EMTALA that because of EMTALA they must treat all patients who walk through the door. But there's a well-established body of cases that show that participation in these programs is voluntary, and that entities cannot premise a takings claim based on voluntary participation in Medicaid and Medicare. And we go through those cases in detail in our briefs, Your Honor. I think another problem with the takings theories raised by my friend on the other side is that they offer no principled reason for why the prior reimbursement rates were not takings, but these reimbursement rates are. They claim that the reason the challenged rates are not just compensation is because they do.
It's because you're downcoding. That's what they say, that you have to downcode. You're not complying with the prudent layperson standard, which is fixed when the person comes into the emergency room. You're basing the coding on your the diagnosis, which results in the downcoding. And that's how I was saying, if the federal code requires the prudent layperson standard, and you all repeal that in Virginia, or require that to be changed, then you're falsifying the forms, because they're supposed to be coded properly. They're supposed to have the 81 code or whatever it is, or the 82 code. When they go in the 84 code or the 85 code, and you put them back to the 81 code or the 82 code.
So I think it bears noting precisely what the prudent layperson standard is, Your Honor. It's such that a prudent layperson could reasonably expect the absence of immediate medical attention to result in death or serious bodily injury without immediate medical attention. And the list that's at issue here is a list of diagnoses that do not present these sorts of problems. That's the evaluation that took place, and that's how this list was compiled. This is a list of conditions that do not merit this sort of high-level emergency treatment. And I think an example helps bearing that out. Somebody preventing with conjunctivitis, certainly it's appropriate to, certainly EMTALA, if it's applicable, requires examination, and if there's a true emergency, stabilization, but it doesn't require extensive treatment of that conjunctivitis. And so at issue here is a question of that next step, that extensive treatment. And so this coding, the reimbursement rates do not violate neither the prudent layperson standard, because again, that's premised on a need for immediate medical attention that might result in serious death or serious bodily injury. But again, I think to the extent there's a policy dispute about whether the list is the right list, whether there's an entry on there that should be in there, that shouldn't be on there. I mean, these are all the sorts of policy questions and just generally whether the list itself was compiled properly and whether the new policy is consistent with Medicaid. That's what CMS was tasked by Congress to do, and CMS is doing that. What's being asked in this litigation is for a federal court to jump in and sidestep that. And I think for all the concerns that are laid out in the Douglas case, that's just not the right approach in this case. If the trade associations disagree with CMS's analysis of what the prudent layperson standard means, they certainly can seek relief as to CMS. And I do think it's worth noting that we do apply the prudent layperson standard because there's still, the reimbursement is still as an emergency. We don't dispute reimbursement as an emergency. It's just as an emergency at the 99281 rate, the different rate.
Counsel, this is Judge Harris. Can I ask you sort of a slightly afield question? The district court dismissed all of these claims, the preemption claim and the takings claim, as a matter of standing. And I think they got this theory from your motion that because the plaintiffs can't win on these claims, they can't get an injunction to enjoin a taking, and there's no enforceable right for which they would have a cause of action under 1983 for their preemption claim, that therefore their injuries are not redressable and there's no standing. Is that the theory that you're advancing in front of us, that the plaintiffs don't have standing because they lose on the merits of their claim? I don't understand that.
I think that's certainly the way the district court understood the
way you argued it to the district court too, in fairness. That's where the district court got the idea. And so can you explain to me, I mean, I guess I don't mean to put you on the spot. Is that what you would like us to hold? That there's no standing in this case because there is no injunction available to stop a taking, and also because there's no enforceable right on the part of providers under Section U2? So that it follows from that they don't have standing because any injuries are not redressable?
I think that's one avenue the court could go. That's not the only avenue the court could go, and I think there are
Why is that an avenue that we could go down? Is there any support for the idea that if someone loses on the merits, they don't have standing?
I think part of it is the idea of how takings claims generally work, whether that's kind of an available remedy. And I certainly recognize that that's kind of an incorporation of the merits in some way. And for that reason, there are various other avenues by which the court can affirm and reasons why that there's a lack of standing here. One of the points that also hasn't been addressed is the representational standing issue. But I think, I think an overarching point is that they're simply in the wrong court, that takings, that for the sovereign interests here, and under 11th Amendment immunity, the proper venue for this case would be in state court. I think
are you familiar with Ex parte Young?
Yes, Your Honor.
Well.
So I think Ex parte Young also, the trade association's claim can't cleanly fit into Ex parte Young because 11th Amendment immunity does not work this. So because of 11th Amendment immunity, in the same way that it might be available for an equal protection or due process claim. That's simply because injunctive relief is just
But they aren't suing for damages here.
That's correct, Your Honor.
They want equitable relief.
That's correct, Your Honor, and that's a sort of relief that's just unavailable for takings claims. The takings clause permits just compensation, not injunctive relief. I do want to note one problem, highlight before my time ends, about the problem with the trade association's theory, and just that they offer no principled way to justify why a reason for this to be a taking, but why the prior reimbursement regime would not be a taking. They take as a given for purposes of this case that the prior rates provide just compensation, but they provide no principled reason to justify that. Their theory is that there must be reimbursement for the professional time, facilities, supplies, and wages actually provided to patients. But even the CPT codes that they advance are not penny for penny compensation for the professional time, facilities, supplies, and wages actually provided to patients. This case is really about healthcare policy, not the takings clause, and the trade association's effort to fashion a case to avoid well-settled doctrines should be rejected, and the decision below should be reaffirmed. Unless the court has any additional questions, we simply ask that this court affirm.
Judge Wynn, Judge Harris, anything else?
No, I'm fine, thank you.
Thank you, Ms. Kalin. Mr. Kimberly.
Thank you, Your Honor. If I may, I'll start out quickly by addressing Judge Harris's question about the proceedings below. I'd point the court to Joint Appendix page 210, which is from the oral argument in the case. It very clearly states, I'll very quickly read. This is me talking now. It says, I understand the state to characterize our position as the view that we have earned these reimbursements. The state is taking them away, and that violates the takings clause. Let me be crystal clear, that is not our theory. Our theory is that the taking is the mandatory provision under EMTALA of emergency screening services in the emergency department. These hospitals and doctors are required by law to use their professional services and medical supplies and equipment to treat these individuals. They have no choice. That is the taking. I would point, Your Honor, also to the very first sentence in our reply brief in support of the motion for a preliminary injunction. This is docket 16, where it says, Virginia hospitals and physicians have a property interest in their labor supplies and facilities, and they are compelled by EMTALA to provide their services and supplies for public use, and the budget items deny them just compensation for that taking. So that's our theory through and through. It has been from the beginning. Judge Harris, you asked the question of my friend on the other side, whether NIC really applies here, given that the injunction that we're asking for is not an injunction against the taking itself. And the answer is NIC can't possibly apply here, because really what NIC confirms is all we're entitled to under the Fifth Amendment is just compensation. The budget items here systematically on an ongoing basis are denying us just compensation. And therefore, as I started out saying at the very beginning, the injunction we're asking for here operates at the second step of the takings analysis. And on this point, I'd point the court to the Colton case. This is a 2017 Seventh Circuit case cited at pages 27 to 28 of our opening brief. This is before NIC overruled Williamson County. And the Seventh Circuit there said, we do not read Williamson County to require resort to state court when state law unequivocally denies just compensation. The court went on to say that in that circumstance, quote, plaintiffs are entitled to prospective relief with respect to the just compensation element of the takings claim. And again, that is our theory in this case. My friend on the other side said that, pointed to cases from the 11th Circuit and the First Circuit, including Baker County and First Medical, indicating that participation in Medicare is voluntary and therefore that this can't be a compelled taking. But on that front, I would note that those cases didn't involve a certificate of need program like Virginia's, which mandate participation in Medicare and Medicaid. and they didn't involve allegations and evidence like we have here at paragraph 74 of the complaint, indicating straightforwardly that 74% of general acute care hospitals in Virginia are nonprofit and public and must participate in Medicare. So Baker County and First Medical are simply distinguishable on that basis. But then, of course, besides that, those cases predate the Supreme Court's decision in Horn. And I would say also, DMAS has to be the right defendant in this case, and that's for two reasons. The first is the injunction that we request in this case would be an injunction that runs against DMAS. The injunction would say simply, you may not enforce the budget items. It would be very unusual, I think, to sue federal agency on the ground that a state agency is following state law in a way that violates the takings clause.
But I don't see that that's, I mean, once if CMS approves these budget items, then you would sue the federal government and say you can't approve these budget items. You federal government have taken our property through EMTALA, and now you have fixed it so we can't get just compensation. That seems like a sensible lawsuit. One defendant, one sovereign did both the taking and the approval of the lack of just compensation. I mean, that's your whole point. It's a partnership, so go after the federal government for both things.
Thank you, Judge Harris. I think the concern with that approach is exactly what Judge King was teasing out. That process will take many years, as the Douglas case itself shows, many years to work itself out.
But that's what the court does allow in NIC. You have to wait until you've been denied the just compensation, and then you'll get it back.
Well, but our point is that we're being denied $55 million a year in just compensation on an ongoing basis. This is not a one-off taking. This isn't the case where, may I complete my answer, Judge King?
You can, and I have another question. So you keep going until we finish.
I'll add, Your Honor. So the fact that this is ongoing, I think, makes it different, and it makes the idea of waiting for the CMS process to work itself out impracticable unless there's a preliminary injunction in place in the meanwhile, which we obviously would be happy to have.
Counsel, I know Judge King has a question. This is my last question. So, I mean, I understand your argument, I think. I don't think the district court ever addressed it, and whether the district court should have or not, I guess we can sort of figure out separately. But the district court didn't understand your argument as you are now phrasing it on appeal. The district court said, look, you're alleging that the downcoding provision itself constitutes a taking. That can't be enjoined. I'm moving on. If we were to think that under your new theory, an injunction would be available, wouldn't we send this back to the district court and maybe even the district court could consider in the first instance your theory that an injunction is available because you're not actually trying to enjoin the taking, because the taking was EMTALA. Maybe the district court should consider that theory in the first instance, or maybe if we want to consider it and say, okay, an injunction is available, wouldn't we go send this back to the district court to see if there has been a taking, particularly in light of the fact that your theory of the taking also has changed since the district court? In the district court, you argued this was a taking under Penn Central, just a plain old regulatory taking. Now you're arguing it's a per se regulatory taking or a physical taking. So shouldn't we let the district court look at some of these new arguments first?
Well, I would say, Your Honor, on the whole, I don't think it's a new theory. Again, JA 210 and the opening line of our our reply on the PI motion. Okay. But I would say I think the material there for the per se taking and the citations and reliance on Horn are all there before the court. Certainly, if this court is not doesn't feel comfortable entering a reversal order with instructions to enter a preliminary injunction, we would certainly take as a fallback.
Well, the district court didn't reach the preliminary injunction issue.
Well, it didn't, Your Honor, and we would be happy for the court to reverse the district court on those grounds, explain that NIC doesn't apply in these circumstances, and send it back to the district court to consider whether a preliminary injunction is appropriate under the circumstances. That, so far as we're concerned, would be an appropriate outcome here.
You're sort of a moving target too here, and I didn't mean to interrupt you, Judge Harris. You go ahead, Judge Harris.
No, I'm sorry, Judge King. I'm finished.
Judge King.
I wanted to know if Mr. Kimberly can articulate what relief he wants.
So what we moved before the district court for, and what we are asking for from this court in the first instance, is for a preliminary injunction against.
I want you to. I know what you've already asked for. Now you've heard the end of the oral argument. What would you like us to do? What do you want us to do? You haven't changed anything?
I think a reversal with a remand to the district court.
A reversal that would say that you have standing.
A reversal that says that we have standing and that Nick is not a bar to this action, I think would be.
That's what's not a bar to the action?
The enunciation in Nick that injunctions against takings are not generally appropriate is not a bar to this action, not a bar to relief in this action, because the relief that we seek is an injunction against a systematic denial of just compensation and not an injunction against the taking itself. I think that's all the court has to say. And in doing so, it would be making clear that.
So you're withdrawing your request for an injunction from the Court of Appeals?
Your Honor, I'm reading the bench. I'm not necessarily withdrawing the request. I have a sense that we're not going to get that, and that being the case.
Well, then I'm asking if you're withdrawing it. I mean, I'm just trying to find out where you are at this point.
No, our first request, Your Honor, is that this court, as it did in the League of Women Voters, remand with instructions to enter a PI. If it isn't prepared to do that, we would be happy with a remand for the district court to consider those issues.
If one of us wants some additional briefing, how much time would you need?
I think we could prepare additional briefing in 14 days or 7 days.
Would you want simultaneous briefing, or would you want it to be seriatim?
I think seriatim briefing is often a more useful iterative approach, but certainly we'd be open to whatever.
I'm not saying we do, but can you? But the first thing you want is a ruling that you have standing, I assume.
A ruling that we have standing. Yes, Your Honor.
Okay, and then something from that. What would you do about this? That outfit that's supposed to be studying on this thing, CMS.
So what, I guess, yes, our position, and this relates, Your Honor, back to what Judge Harris was asking about as well. CMS is in the process of reviewing the budget items. It is a process that will take many years. The budget items, meanwhile, are being enforced.
It's a process that'll take several years?
Yes, Your Honor. In Douglas, it took 3 years. And already CMS—
You mean they can't decide whether this downcoding thing is proper or not?
It takes time. It takes time for them to—
Looks to me like they're supposed to be experts. They could decide that in a couple hours.
Well, I might have thought so too, Your Honor, although as a lawyer here
you're
in
asking
DC,
you're asking us to do it immediately.
Well, actually, Your Honor, all I'm asking for on behalf of my clients is a maintenance of the status quo while that takes place, which we think is only appropriate.
Well, that's an injunction. That's what it's called, isn't it?
Yes, a preliminary injunction. Yes, Your Honor. Correct.
Right. All right.
So if I may, there's just one other brief point I'd like to make, and that's that DMAS here is the entity that's turning the screws in an unconstitutional way. It's the one that's saying if you don't like giving uncompensated care to Medicaid beneficiaries, it's on you to disenroll from Medicare or to close your ER. And in that sense, we think really certainly the reasoning of Horn applies here as to DMAS, and it's the appropriate defendant. And certainly also there is a principled way to differentiate this case from general complaints about below cost reimbursements, because as the court in Horn itself said, the Constitution is concerned with means as well as ends. And here, for all the reasons we've given, we think the downcoding provisions are both preempted by U2 and work in unconstitutional taking, and we ask the court to reverse.
Thank you, sir. Let's do it. Wait a minute. Judge Wynn, Judge Harris, you have anything further?
Nothing further, thank you.
No, thank you.
Thank you very much, sir.
Thank you, Your Honor.
If we were in Richmond, where we'd like to be, we would come down and greet counsel and tell you we appreciate your work and thank you for it, and that you've done a good job. And we'll do that the next time you're there. Thanks very
Hopefully
much.
another time soon.
Madam Clerk, you can adjourn court
Yes,
until
sir.
tomorrow.
This honorable court stands adjourned until tomorrow. God save the United States and the honorable court.